on the question of what is for cause, what the district court held was that it must relate solely to in-office conduct. And you defend that with one caveat, that if the office holder is indicted while in office for pre-office conduct, then that might be cause for removal because a person under indictment wouldn't be able to devote full attention to the job. But other than that, you defend the district court's holding. Is that correct?
We do defend the district court's holding on that, and I would understand that is the rule for all the statutes that have INM.
There's nothing when under a for-cause removal standard, there is no pre-office conduct that could constitute cause.
That is my frontline response. I happen to have a backup argument, which is if you pick up the common law, then you would pick up
let's take your frontline argument first and see how far you're willing to go. Suppose that the office holder was permitted to resign from a previous job under a non-disclosure agreement based on long and egregious pattern of sexual misconduct. That would not be for cause. That would not be cause for removal.
So what I would say, Justice Alito, is I don't think that would be INM. And so if I'm going to stick to my frontline position, then that would not be for cause. It would certainly be a basis for impeachment. And I think in understanding why we've had INM for at least 90 years.
All right, I understand your position. How about if after the person assumes office, videos are disclosed in which the office holder is expressing deep admiration for Hitler or for the Klan?
I can only imagine where these typos are going to eventually go, Your Honor.
Well, yeah, because your position
I'm going to stick with my position.
Well,
of course I'm going to stick with my position. And I'm going to say that's an official that would be impeached in a heartbeat, and the fact that they would be impeached in a heartbeat is going to cause them to resign in half a heartbeat. And this has not proven a problem. I mean, for better or for worse, whatever you think of Humphrey's executor, we've had 90 years
Mr. Clement, what's your backup argument?
My backup argument is the common law standard. Justice Sotomayor alluded to it, which would be that there's a removal basis for an infamous crime of the kind that is disabling for public office, and and at common law it also required a conviction. So it's an exception. It helps me with a couple of these hypotheticals.
No, it doesn't
but it's
help
not going to help me with the Justice Alito.
It doesn't help
saying
you.
There's
It
no
doesn't-
conviction for the Hitler video.
Do you have a backup to the backup?
Impeachment. It's the ultimate backup here. This is not a situation where you're being asked, have to tie yourself to the
argued in the past that impeachment